to get right on to the Don Juan Moses case to address the deeper issues that we're getting close to now. I'm just listening to a recording of Shannon Karam, the attorney for the Pine Tree Legal Defense of DHHS, and I realize that there is a very important thing to do, and that is to specify how the boy was not allowed to speak, to show from the court trial that the judge had set up an arrangement whereby either the boy come in or the video is submitted in his behalf. Since the video represented to DHHS in their false and hasty adjudication without investigation the presumption that Don Juan Moses was coaching his son, naturally the inference can be made that once the judge got the video only, the judge would simply rubber stamp what DHHS had stated. That's the basis of the mischief of Judge Cashman in this matter. And so I just want to explain that what took place was nothing less than a mockery of justice, as I saw when I woke up one morning. I was shown to warn the judge that it would be a mockery of justice if you were to continue the way you have during the trial. That warning was not taken to heart, and so Judge Cashman is now under review by higher court if they are willing to give Don Juan Moses the extension that he's requested because of his untenable conditions, certain extenuating circumstances that are as obvious as they can get for a reason for an extension of time to submit the brief. But I just want to clarify that the mischief, the chicanery performed by Judge Cashman is none other than offering either Kamani to come in and speak for himself under sequestered and controlled under a sequestered and controlled environment, or taking the video that is already presumed to be evidence of coaching. So, discerning the malice implied in that either-or decision, we are taking this to the next level, and that has to be the focus of this case as far as I can see. Judge Cashman, I listened to the recording just now, stated to Don Juan Moses that we already agreed that you could have one and not the other. The actual wording of that needs to come out. I need to go back and find out the particulars on that. But I understand, and I hope the transcript will reveal that Don Juan Moses was given a choice between allowing his son to come in or the video. That's what he told me anyway, and I want to make sure to confirm that before I say it. But I need to go check it. But if that's true, and this is what I wrote yesterday, if that's true, it means that the DHHS is responsible for placing these children in the untenable and brutal conditions of subjection to and slavery to an open season of pedophilia and or child abuse by multiple parties. The son of the boyfriend himself having wiped the child so hard that he vomited in a projectile fashion upon taking the first bite at the family meal the subsequent day. How many days of that, I need to ask Don Juan Moses. The child was not able to sit properly without excruciating pain. I saw it personally and witnessed that in the courtroom, and the judge decided to go with the defense attorney Shannon Karam's objection, which is that it was hearsay for me, and I said that I had been there with the child, and yet the judge excluded that, struck it from the record. Another malicious evidence of fraud upon the court to prove, to sabotage, to militate against the witnesses that Don Juan Moses brought to court by a judge. The chicanery and the duplicity of Judge Cashman is explicit in this particular. Judge Cashman would have either the child come in to speak for himself under conditions that she would orchestrate and control, having already displayed a deliberate support of the DHHS agenda to stereotype Don Juan Moses as an angry, jealous, controlling African-American man with a white girl. In the context of the sexism that is like a cement foundation for a house in this country, which says that if there's any question and a woman accuses a man of abuse, she'll get the children. That is what we challenge at the Supreme Court level, as I can only imagine must be necessary as a byproduct of this. Or I should say as the core of this, because that's what's happening. In addition to that, of course, the conflict of interest woman that was used by DHHS displays the bias in the most flamboyant way. For indeed, it was Christine Lynn Ash, the investigator, the primary investigator, who wrote out the narrative that was based on 5.5 years of abuse that was never reported to the police conspicuously, which is a violation of a mandated reporter. And her lame excuse in the courtroom was, I wasn't sure if the children were there when I heard the violence, the slamming of doors, the obscenities, the insults, and the such things as she claims to have heard. No doubt they've had arguments, no doubt. But it is not in the purview of DHHS to claim domestic violence when parents have arguments. That does not place children at risk. And that is the crucial core of this issue, among other aspects of the core. So the duplicity of Judge Cashman is displayed in the either-or scenario. Bring the video in showing that the child is speaking for himself, that he is being abused as evidence of being coached, and slam dunk it that way and retain the custody for Jessica Pinkerton, or have the child come in. Have the child come in and let the child speak in what can be interpreted as finally being given a chance within a safe and neutral environment to speak for himself. The danger of that is that the explicit and infamous bias that has already been demonstrated by DHHS means that the sequestering of the child for the purpose of interviewing the child would simply be a further display of the DHHS and judicial collusion to defame Don Juan Moses, to stereotype Don Juan Moses, to stigmatize Don Juan Moses under bias that is both sexist and racist. Because there is a racist dimension. It is not the major thing, it's an overtone. But it also is there as we look at the bigger picture of the police and how they factor into this story. All of that is covered in what we are writing, what we are presenting, so that people can have an opportunity to see for themselves all the evidence, and so that we can allow for a different kind of justice in America, a justice that allows the people to speak freely and openly, to have witnesses speak freely and openly, to challenge the tainting of witnesses, the tampering with evidence, to challenge the witness tampering, to push through and allow true witnesses to take over courts, replacing false witnesses, to impugn, to indict false witnesses. That's all part of what is needed in order to establish true justice. We come back to the two pillars of American justice, or justice anywhere, the rules of evidence and the rules of procedure, and we recognize that due process is being violated. The access of Moses to this court has been obstructed because his witnesses have been blocked.